In this second recording in the legal issues module, we'll focus on participant and premises liability, and the content is divided into three sections. First, we cover general concepts of negligence. Then we focus specifically on participant liability before taking a look at premises liability. So negligence, just like we discussed in the opening recording in this module, is conduct that falls below the standard established by law for the protection of others against unreasonable risk of harm. Therefore, as this statement sort of implies, it's really important to understand what constitutes the standard. If you dissect the concept of negligence, then it definitely involves personal injury, but there are four requirements: that there is a duty alongside a failure to act as a reasonable person would, so a breach, and then this breach of duty causes damage or damages, or in other words, the personal injury as just mentioned. However, unlike intentional torts like assault and battery, with negligence the injury is caused without intent, and as such the standard is based on fault. There are a couple of general defences to negligence claims that are relevant both in terms of participant and premises liability. The statute of limitations is the defence that the cause of action has not been filed in a timely fashion. This defence is a procedural one, not a substantive one. So even if the case has merits, it will be dismissed if not filed in a timely manner. So each state has legislation that specifies the time period in which to bring a certain cause of action. You just might be able to make out on the table on this slide that in Maryland, the statute of limitations for personal injury is 3 years. Another general defense is the act of God, okay, and the defense rests on the idea that a person has no liability if an unforeseeable natural disaster resulted in injury to the plaintiff. There must truly be an act of God, like a natural disaster, like a storm, lightning, earthquake, flood, or hurricane that caused the injury. And this act of God must have been unforeseeable, because if it was foreseeable, the defendant may still have liability since they did not act reasonably in protecting the plaintiff from the disaster. For example, if a player is struck by lightning during a baseball game, the coaches will not be liable because it is a natural occurrence which he or she cannot control. As you can see from the hierarchy chart on this slide, negligence is divided into management of premises and the supervision of participants. It's at this point where we turn our attention to each one individually. So following that fork down from negligence to premises and supervision, it is participant liability that relates to supervision and the supervision of participants. So participant liability includes the legal responsibilities to those who participate in your programs and services. There are four common liability issues regarding participants. That's lack of supervision, improper instruction or training, unsafe use of equipment, and improper medical care. Quality of supervision involves the competence of the supervisor, in particular his or her ability to identify dangerous behaviour and therefore to intervene and stop the behaviour. Quantity of supervision is whether the number of competent supervisors is sufficient relative to the number of participants. But quantity of supervision is not always something that is explicitly clear and often requires organisations to make informed judgment based on some kind of wider framework. Take for example swimming. The American Red Cross and its lifeguard management guidelines state how some state and local health codes specify that a certain number of lifeguards must be on duty for a given number of patrons. For example, the county health code may specify that for every X number of patrons in the water, the facility must have one lifeguard on surveillance duty. Other codes may have guidelines based on ratios of pool surface area to number of lifeguards. Improper instruction or training boils down to the question, does the instructor have the appropriate competence to provide instruction? As Dolshall suggests, and it's important that his thoughts relate directly to sports coaches, proper instruction includes progression, complexity, and safety. Okay, so in terms of progression, does the instructor have the ability to instruct each skill level using a progression that moves from simple to complex and from unknown to known? In terms of complexity, can the instructor break down complex techniques into its simplest parts and then teach those parts to the participants? And then finally, safety. Does the instructor continually teach and reinforce the safe way to perform a specific maneuver or skill? I have included Dolshall's article on Canvas under supporting resources because while the content does relate to sports coaches and it's also in the interscholastic setting, the author does go on to discuss 13 other duties of care that are relevant across various different settings, whether you are a sports coach or an outdoor activities instructor. Another common liability issue regarding participants is unsafe use of equipment. So recreation providers must provide necessary equipment that is proper and safe for an activity. Okay, so if necessary protective safety equipment cannot be provided, the activity should be discontinued. Okay, the courts do not view lack of funds as a legal defence, and the equipment provided must meet the standards mandated for that type of equipment. For example, to meet US Coast Guard requirements, a recreational vessel must have a US Coast Guard approved life jacket for each person on board. The last liability issue regarding participants I want to discuss is improper medical care. So issues under this category can fall under two subcategories. So first you have preventive health concerns. So providers of activities must have a screening mechanism to ensure that players are healthy enough to compete in activities. Okay, so like a medical history form or echocardiograms. All right, second is emergency medical provision. So providers must make sure that qualified personnel are available to render emergency first aid and ensuring that there is a protocol to get in outside medical personnel to the site as quickly as possible. Vicarious liability takes into consideration that the employer generally receives the benefits of its employees' actions. The notion of vicarious liability is also predicated on the employer's ability to control employees and to procure insurance that covers the actions of employees. In this way, employee liability is a cost of doing business. But the doctrine of vicarious liability holds an employing organization responsible for certain acts of its employees, not because of any wrongdoing by the employer, but because the law has deemed it appropriate for the employer to be held accountable for the actions of its employees. In the diagram on this slide, the principal becomes the manager or the managing organization, the agent is the employee, and the third party is the participant. The concept of vicarious liability and also that of respondeat superior are where negligence crosses over with contracts and contract law. Specifically, job descriptions or employee contracts don't always necessarily capture the full extent of an employee's scope of employment. For example, if a whitewater rafting guide drives negligently while transporting rafters to the launch site, that negligence will certainly be within the instructor's scope of employment, even if the duty of transporting rafters might not specifically have been listed within the guide's contract. However, an employer will be responsible for the acts of an employee so long as the acts are done within the scope of employment to advance the business of the employer, and conduct is considered to be within the employee's scope of employment if it is of the kind he is employed to perform, it occurs substantially within the authorized time and space limits, and it is actuated, at least in part, by a purpose to serve the master. The negligence of a manager in hiring, supervising, or retaining may lead to vicarious liability for the employer, since the actions of the manager in dealing with these employment-related decisions are most likely within the manager's scope of employment. As you can see, negligent hiring is concerned with the risk created by exposing members of the public to a potentially dangerous or unfit person. Negligent supervision is when someone who has a legal responsibility to supervise others fails to do so in a responsible manner. And negligent retention issues arise when a manager receives negative feedback about an employee or has direct knowledge of an employee's misdeeds yet does nothing to discipline or discharge that employee. Then, beyond the general defences to negligence discussed earlier in this recording, there are two further defences available in participant liability, which is contributory negligence and assumption of risk. If the plaintiff's or participant's conduct falls below the standard of care, then the plaintiff is said to be contributorily negligent. Okay, so as a hypothetical example, picture a novice skier who, as part of a ski lesson, collides with a tree, sustaining a severe injury. Say the novice skier had been taken out by the same instructor earlier in the week, and the class had gone off-piste, which the novice skier found difficult. So it became evident before the day of the injury that the novice skier was one of the weakest members of the group in terms of experience and ability. The evidence suggests that the instructor should have taken account of the needs of the novice skier. However, the evidence may also suggest that the novice skier, an adult, should have voiced their concerns. Under contributory negligence, if the court held that the novice skier contributed to the negligence, then there is no recovery for the plaintiff, which makes contributory negligence rather harsh, which is why many states use comparative negligence. So in this same example, the degree of negligence by the plaintiff is compared to that of the defendant. In this particular example, a strong argument exists that the ski instructor demonstrated a greater degree of negligence. In other words, would a reasonably prudent person have taken an inexperienced novice skier on a challenging off-piste run? Assumption of risk is the defense that is discussed most often in the context of physical activity and sport. Primary assumption of risk means that a plaintiff understands and voluntarily agrees to accept the inherent risks of an activity. The inherent risks of an activity are those risks that are obvious and necessary to conduct the activity. Secondary assumption of risk bears a number of similarities to comparative negligence, which we discussed on the previous slide, but secondary assumption of risk means that a plaintiff deliberately chooses to encounter a known risk and in doing so acts unreasonably. As a result, in many jurisdictions, the notion of secondary assumption of risk has been subsumed by this idea of comparative negligence. Finally, let's spend a bit of time discussing premises liability, which relates to the legal responsibilities to those who use your land and facilities. The duty owed by a facility owner or operator is dependent upon the status of the person who is on the premises. Therefore, there are typically three types of persons upon the premises to which a facility owner or operator has a duty. They are invitees, licensees, and trespassers. An invitee is a person on the property with the permission of the landowner. A business invitee is on the premises with the permission of the landowner and also brings some economic benefit to the landowner, like they are a paying customer. Public invitees, on the other hand, are persons who are legally on public land, but they're kind of attendees of a community event at a local park. All invitees are owed a duty of reasonable care, and the example you have here of a family accessing a paddle boat at a local park is of a business invitee, okay, because they're on the premises with permission and they're bringing an economic benefit. A licensee is a person who is on the premises with the consent of the owner but who does not bring any economic benefit to the owner. The landowner is liable for harm due to defects or dangers on the property only if the owner has knowledge of the danger and the licensee does not. So an example here would be parents who attend their children's summer sports camps. All right, the difference here is that the training camp, it had likely not been advertised to the public, it had no entrance fee, as well as no official seating for spectators. So these parents are permitted on the property due to their son or daughter's involvement in the camp, but are not bringing any economic benefit. By and large, the landowner has very little or no duty of care to trespassers. A trespasser is one who is on the premises without permission, and the landowner's duty of care is to refrain from wantonly inflicting injury upon that person. This table provides a useful summary of the different visitor statuses as well as the duties of the premises owner. And as you can see, the only difference from this table from the previous few slides is that this table differentiates between a licensee by invitation and an uninvited licensee. But what are the duties that are owed? A facility owner or operator has a number of obligations to safeguard invitees, which include the duty to design the facility safely, the duty to warn, the duty to inspect, duty to repair dangers, and the duty to provide medical assistance. Facility owners and operators have a duty to design the facility safely, a duty to inspect the facility, and duty to repair dangers within the facility. Okay, so in terms of the duty to design the facility safely, there is it has to relate to its intended purposes. Okay, and if there are mandatory safety standards that are in place, you must ensure that these standards are adhered to. In terms of the duty to inspect, the facility possessor has the duty of reasonable inspection to discover damages. And what is reasonable inspection depends upon the frequency and type of use of the area. And then finally, duty to repair dangers. So after a property owner through the duty to inspect has a notice of a danger, the danger must be repaired or remedied within a reasonable time period. Reasonable behaviour may mean that a danger cannot be repaired quickly, but that users are kept away from that particular dangerous area. Each year, about 200,000 children are treated in US hospital emergency rooms for playground equipment related injuries, and an estimated 148,000 of these injuries involve public playground equipment. So public playgrounds, they become one type of facility where it is of paramount importance to have established guidelines for design, inspection and maintenance. I've included the CPSC's handbook on playground safety on Canvas, but of course most states will have a local interpretation of these national guidelines. Facility owners and operators also have a duty to warn, and this duty exists to warn invitees about hidden dangers, like those dangers that would not be obvious to an average user. So the best example I can think of here of a hidden danger is perhaps that of rip currents at beaches. Right? And there are dangers here that are not obvious on a simple glance and takes a trained eye to actually foresee these dangers. We talked about medical care when discussing common liability issues relating to participants and the role of supervisors and instructors, but facility owners and operators also have a duty to provide emergency medical assistance. Specifically, a possessor of land has a duty to give business invitees first aid after the landowner knows or has reason to know that they are ill or injured, and to care for them until they can be cared for by others. In the state of Maryland, there is legislation in place that mandates swimming pools to have AEDs, as well as high schools and middle schools. There are two premises-specific defences to negligence. The first is that the danger is evidenced as being open and obvious, and the second is immunity, provided by recreational use statutes. The first defence is that the danger is open and obvious, which means that if the danger is one that a plaintiff should be or actually is aware of, then the plaintiff has assumed the risk of that danger or defect. Swimming pools are perfect examples. Just the nature of the activity means that water from the pool can be transported elsewhere on site to create puddles of water that, as the sign says, are of course, these areas are slippery when wet. Recreational use statutes provide a level of immunity for landowners who open their property to recreational use by the public with no fees charged. I have included a couple of supporting materials on Canvas. The first provides a more comprehensive definition and discussion of recreational use statutes, and the second presents an overview of the existing recreational use statutes at the state level. Similarly, many states have passed a Sports Safety Act or Shared Responsibility Statute to safeguard outdoor activities that are important to the economy, like skiing, whitewater rafting, and golf, to provide that participants in an activity assume the risks and hazards inherent in that activity. Again, I've included another supporting material on Canvas, an article which presents an overview on a state-by-state basis of the existing Sports Safety Acts. Interestingly, in the state of Maryland, there is not a Sport Safety Act, but in neighbouring West Virginia there are statutory provisions that protect snow skiing, equestrian and whitewater rafting activities. So this was sort of a lengthy recording, but as mentioned in the previous recording, there's just so much to cover when it comes to legal liability, and we've taken a deeper look here at two areas of law that you and your agency likely manage proactively on a daily basis. And we end the series of recordings this week by looking at risk management. Take care, everyone.